It is a beautiful October day, and thank you for spending some of your day with us. Welcome to Elville and Associates Elville webinar series. Today, a new topic, the critical need to update your estate planning, presented by Elville and Associates Managing Principal and Lead Attorney Stephen Elville. My name, as always, is still Jeff Stauffer, Community Relations Director with Elville and Associates, and I'll be your moderator for today. We appreciate those that are new to our webinar series and also to those that are frequent attendees as well. You've come to the right place for some high-level education. And as always, we encourage your general questions today. The only bad question is the one that is not asked. So please note your questions in the questions panel on your screen, and we will pause periodically throughout the presentation to address them. Your questions always add value. They help others learn, so pose your questions at any time. You also received the presentation slides by email yesterday for me to take notes if you wish. These materials are also available in the section marked handouts in the panel on your screen to download at this time. For our professionals on today's webinar, a warm welcome as well. 1.5 continuing education hours are available for most everyone in attendance. If you'd like to submit an ID number and your accreditation for me to provide a certificate of attendance or submit your information to the CFP Board of Standards, please send the information to me if I don't have it already. Everyone will also receive a post-webinar feedback email right after the presentation, so please take just a couple minutes to fill out this very brief survey and offer us your feedback about today's presentation. We always read and value every comment that you have to share with us. And here at Elville & Associates, we always want to be a resource to you for your families and your planning needs. So if you have any planning needs to address, old documents that need to be reviewed, which we'll discuss in depth today, or even another matter, consider a consultation with Steve and use today's education as a jumping off point to get your planning started or updated. Consultations are an ideal way to get your specific questions answered, have Steve understand your situation, and help create solutions and a path forward. So I'd like to offer Steve and the firm a proper introduction before we get started, and then we're gonna jump right in. So you should be able to see my screen here. Elville & Associates, founded in 2010 by Stephen Elville here in Columbia. We have several different practice areas that we focus on here at the firm on a daily basis, including estate and trust administration, estate and special needs planning, elder law and elder care planning, business law and succession planning, guardianship and litigation, tax planning and asset protection, which falls into estate planning and elder law. We have 9 attorneys, 12 staff members, and 5 locations. Steve and I are coming to you live from the Columbia Gateway community today. Our mission, as it always has been and always will be, is to provide practical solutions to our clients' needs through counseling, education, and superior legal technical knowledge. We focus on education a lot here at Elville & Associates, and we do that in several ways. Through our planning processes with our clients, we offer many, many educational webinars and workshops in the communities that we serve each year, and also by way of our accredited client care program. We're one of only 2 firms in Maryland to have an accredited client care program through the Client Care Academy in Boston. We also work with the ideals of client education, collaboration, and compassion in mind every day with every client here at Elville & Associates. Just a bit about Steve. His work as an attorney for the past 20+ years has been centered in elder law, special needs planning, and estate planning. A member of many different national membership and professional organizations, including the National Academy of Elder Law Attorneys, the Academy of Special Needs Planners, and the National Network of Estate Planning Attorneys, among many others. He works to bring peace of mind to clients by offering solutions to their needs through counseling, client education, and the use of leading-edge legal technical knowledge. A very seasoned speaker, if you haven't heard Steve present before, offering many webinars, workshops for businesses and their employees, conferences, and continuing education events each year. Steve was also named to the Maryland Super Lawyers list for an 8th time in 2023 and a 7th consecutive year. He also had a feature story written about him in the National Super Lawyers magazine about the Elville Center for the Creative Arts, which is our firm's charitable organization he founded in 2014. I'm also very privileged to be the executive director of. So if you'd like to learn how we work to make a musical difference in the lives of children each day, please feel free to reach out to me. I would love to share our story with you when we have just a bit more time. But today we have an important topic to discuss, updating your estate planning. I have a very brief poll I'd like to offer you and get your thoughts on. Pretty simple one. Something we'd like to get your feedback on. The question is, how long has it been since you updated your estate plan? And the choices are, I want you to be honest here, less than a year, 2 to 5 years, 5 to 15, 15 to 20 or more, or I don't yet have an estate plan in place. So go ahead and make your choices there, if you will. Appreciate you being here today on this beautiful day, even though the Orioles lost last night. But 101 wins is still not bad. And there's always next year. They'll have some playoff experience under their belts. They'll be back better than ever. We'll give it another 15 seconds or so. All right. We have about 70% of our attendees having cast their choice. We have 13% saying less than a year, 23% saying 2 to 5 years, 27% say 5 to 15 years, 6% say 15 to 20, maybe more, and 29% say I don't yet have estate planning in place. All right, thanks for sharing. Keep coming back. Steve, I'm going to make you the presenter.
Thank you, Jeff. Thanks for getting us going in the right direction.
All right.
All right, I'm going to show my screen. I'm going to get my presentation up here. And Jeff, can you see my presentation as I make it the slideshow? All right, thank you, sir, for that excellent introduction. Good morning, everyone. And as Jeff said, it's a beautiful day. I'm sitting here in our conference room #1 in Columbia, Maryland. I have a nice view of the outside. I hope you're in a beautiful place wherever you are. And we've been very blessed this last 2 or 3 days here in Maryland with just excellent weather. So happy Wednesday to you. We know you could be anywhere this morning and you're spending your time with us. We're going to bring some real substance to you this morning and give you some tools. And for those of you who are advisors or non-professionals, people who have estate planning, people who don't have estate planning, we really appreciate it. I could not do what I do all these years without people like you who would be interested in improvement and interested in educating yourself, and without our colleagues like Jeff and our 9 attorneys here at Elville and Associates and our staff. And so we just welcome you, and we're privileged to be with you this morning. So my job this morning is to share my experience. This is kind of a mini master class on this subject, and I'm going to be intentionally redundant. Jeff and I have often said, and I've often said, you know, when someone asks me when we're in a conference together and they say, gosh, Steve, how do you know all this stuff? Well, I didn't wake up one morning and just realize all of this stuff. It took years, and I had mentors, and I went to educational conferences all across the United States. And so if I can be of any value to you this morning, it's really bringing you a compilation of my experience in a nutshell, and then hoping that this kind of nutshell substance that I can give you really will stick and that you can walk away with some bullet points. And this is going to be interactive. And again, my goal is to really just bring up concepts and then intentionally circle back to some of these concepts over and over in a different way, and hopefully in interesting ways, so that by the end of the discussion, you have something substantive to walk away from. So the 2 goals really are to give you the tools to make decisions, to analyze where you are, and then move forward from where you are. And that really obviously is the second goal, which is to give you a path forward. So this morning, I was very privileged to meet with a very successful professional in the financial planning and estate planning world, and gave me a new set of reference points of just the passion of really helping people, to help people from the fundamentals and from the ground up and really just drilling down into those fundamentals to make sure nothing falls through the cracks, and that what a joy it is to have the privilege to be able to do that. So that is why I'm with you this morning, and we're going to get started. And thank you, Jeff, again for that excellent introduction. So of course, this can't be construed as legal advice because we are giving an informational webinar here this morning. So we can engage in an attorney-client relationship, but this information this morning is high level. It's counseling, but it's more educational, and it's not really legal advice. So we're not in an attorney-client relationship, but certainly we could be. So just know this is for educational purposes only. So what are we going to review today? Well, we're going to understand the purpose of estate planning and the importance of having a process. And that word process, if I had to redo this slide, I would probably make that word in all caps. So process is the difference between success and failure. And we're going to talk about that. We're going to understand client education, meaning the education of someone like yourself, but also the education of your fiduciaries, your trusted advisors, your trusted agents, your personal representatives, your trustees, your healthcare agent, all of those people that are in a fiduciary role. We want them to be educated. We want to understand incapacity planning, and how could that be the most important thing in estate planning, arguably. So how can that be? We want to understand that. We want to understand partnership and maintaining and updating a process throughout your lifetime. And we want to understand asset alignment. How a person owns their assets, how does that affect their estate planning? And how could that arguably be one of the most important things in planning? We want to understand document review and how to take next steps. Some people want to take next steps just for maintenance, but other people want to take it one step further, and that is to achieve perfection. So we're going to talk about that. We're going to talk about being intentional. We're going to talk about how to understand risks in estate planning and knowing what you want and being able to have a goal. And if you don't know what your purpose is or your goal is, how to use counseling to have these goals flesh out, to have an epiphany of what your goals might be. We want to avoid planning failure. We're going to put some emphasis on that. And we're going to talk again about maintenance and updating and partnership. What is partnership in estate planning, and how is that so important to your success? So let's understand process. So there's lots of reasons why people want to plan, or maybe you did planning years ago or 5 years ago or updated 1 year ago, whatever that may be. And so I want to take about 60 seconds here to really say, you come to this webinar for various reasons today on this beautiful day. You have questions in your mind. Maybe you woke up at 3 o'clock in the morning 5 months ago and you said, gosh, I have this question about taxes, or how to take care of my parents, and what's happening with my own planning. Whatever it may be, politics, how that's affecting planning and taxes and so forth. But each of you come today to this webinar to spend your time for a certain reason. Let's take about 60 seconds. Take your tablet, take your iPhone or whatever Android phone that you may have, take a piece of paper, whatever you have. Let's spend 60 seconds asking ourselves, what is the reason we are here today, and what do we want to get out of it? And as I start my timer for the 60 seconds, I want you to just let this flow. What is of concern to you about your planning? Why would you even be concerned about updating it at this point in your lives? What health situations? What situations with children or grandchildren? What situation with someone who in your loving circle of family members is getting divorced? What is happening with goals that you might have about passing on your legacy or protecting assets for someone? What is this concern that you have that's brought you here today? Let's take about another 20 seconds and there are no wrong answers. And some of you may want to share some of these things with Jeff, and Jeff is going to let me know if you have questions. Some of you may want to keep this private. 5 more seconds on this. Okay, my timer says that the time is up. Use that set of reference points for, let's say, laying the groundwork for what your goals might be, and then to be very clear about what you hope to get out of this webinar today, to walk away with as more tools for you and what your concerns really are. So we want to plan, we want to have a goal for planning, and we want to keep in mind that if we don't do it correctly, it can fail. And failure, of course, has its own definitions. It could be a huge catastrophic failure where we wanted to accomplish something, but it didn't happen at all. Or it could just be that the plan works less than perfection. And so we want to just keep in mind that plans can fail. Now, many of you have these kinds of goals. You want to provide certainty or smooth administration or minimize the cost of administration after our deaths or during our lives. Know with certainty that we're providing asset protection for spouses, children, grandchildren, nieces, and nephews. Some of you are achieving your special purposes like charitable planning or other types of specific goals that you have. Some of you want to minimize taxes, and this is a big issue traditionally in estate planning. And then some of you have yet to define what your definition of estate planning is. So that's what we're really talking about this morning, not just the importance of updating, but really understanding the why. So as we think about this, just remember that all estate planning is goal driven. You must have a purpose, you must have a desire, you must have some kind of reason, even if it's simple. You know, I just want to get everything in place. I just want to know the certainty of it. But have a goal, have a purpose. It takes commitment. It takes commitment to do good planning. How many people in this country have planning? Let's talk about that real quick. So about 45% of people actually have planning across the board. That means that 55 to 62%, somewhere in that area, of people in this country have no estate planning. So it does take commitment, and the numbers bear that out. Now, Jeff had asked early on how many people have updated in the last 20 years or so. And he gave various ranges and so forth, and that was a lot of fun. So it takes commitment not only to do planning, but it takes commitment to keep the planning updated. And so that's where partnership comes in. You want to make sure that when you're doing planning that matters to you, that you are engaging in a partnership relationship with estate planning attorneys or this tremendous financial advisor I met with this morning for breakfast who is so committed to the long-term commitment of the partnership relationship with clients, CPAs that are in partnership with you for tax planning. This takes partnership, and we want that. We want that for every client. And it requires some level of endurance. You know, you're here this morning on a morning where you could be doing anything with your lives, but you're spending that time drilling down into these educational materials. So it does take some endurance. And on some level, estate planning is driven by love, in my opinion, the love that you have for your spouse or your children or your grandchildren or nieces or nephews or your special cause. And that love, that passion is what's driving your estate planning. So we want to, avoid a less than perfect estate plan. So we won't dwell on the negative here, but we want to be mindful that it can happen. So we want to look at what is our goal at the end, what is the goal, and that's why we started with that. But at the end, right, we have this result. So we want to visualize that result, and then we have to say, well, okay, what do I have to do that? Can I put planning in place and then ignore it for 19 years? 19 years is the average that we know that the good people, the people that actually do mindful things like estate planning, we know that even those people do not update for about 19 years at a time. Those people on this webinar who updated sooner than that, much quicker than that, congratulations, you are way ahead of the average person. So we want to work in partnership and an educational process. We want to use legal, technical, advanced techniques where they are appropriate, not just for the sake of making things complicated, but for the sake of making sure that you're educated about the knowledgeable choices, I guess, the informed choices that you can make. You want to work with a firm that has a funding and alignment coordinator. What does that mean? That means that you could have a great estate plan, but if the assets are not funded or aligned properly with the estate plan, you will not achieve your purposes, because how assets are titled is a hugely important thing. We want to maintain and update documents over the years in a reasonable way to make sure that changes in the laws are accounted for. And we want to have a succession plan. So let's say that you're working with a financial advisory firm, you're working with a law firm, you're working with a CPA firm. Well, all of those professionals should be working together in a planning team concept. This should be your planning team. And this morning we were talking at breakfast about making sure that not only we have a planning team, but that planning team is actually talking to one another, communicating with one another in the best interest of you, the client. So we want to make sure that we have long-term succession plans, that when these advisors retire or die, God forbid, that your family is supported through a succession plan. So that's not a small thing. And we were just talking this morning about the shortage of CPAs currently. There's a tremendous shortage of CPAs. So we all want to be mindful about the longevity of our advisors and of our planning team as we think about the long-term success of our plan. So as we continue just to talk a little bit about this failure process and how we want to avoid this possibility. So the first way to avoid it is to be mindful, obviously, have goals, understand that it's not a transaction, it is a process. Planning is a process. You can put planning in place today, and it could be somewhat obsolete 3 or 4 years later, because changes in the laws, changes in your family situation, changes in the world and how things are looked at from a tax perspective, new fiduciary possibilities that are developed in the law. For example, the Maryland statutory power of attorney, which is our new power of attorney in Maryland since 2010, that was just recently updated and became effective October 1st. So there are new choices available. We want to make sure that we are following up simple maintenance and updating, drilling down into the fundamentals, and this is the way to avoid failure. And we avoid failure by being intentional. Now, some of these are excerpts from a larger intentionalism webinar that I have given, and we're happy to send that to you as well. But let's drill down into the word intentional for just a minute. So as we're talking about the importance of updating, the importance of having a process, which we're going to continue to talk about, let's talk about being intentional. So very simple, from Webster's dictionary, done by intention. This is something that is done by intention or design. So that makes sense. I'm being intentional. But here's something that really resonated with me. Having an external reference. So doing something by design, doing something with intention, but having an external reference. And I thought about that and I said, oh my gosh, that is what I'm talking about. The need to have a process. So being intentional with this external reference, in my opinion, which is process. You can be intentional through a process. So of course, the synonyms include consciousness, deliberation, intentional, knowing, and purposeful. But of course, we want nothing to do with an unintentional or a non-deliberate estate plan. So we want to be intentional, mindful, and really have reference to this external process. So we could define an intentional estate plan as one that is designed and done with conscious and deliberate intention with reference to an external process. If we have to have a process, or we're going to be subject to what? Randomness, and we cannot have that if we're going to have an updated and ongoing estate plan. Now, we can define it all day long, but what do we have to do to make this happen? Well, you have to have two things in my view. You have to have commitment, and that is 100% within your control, just like this morning, you being here and participating in this. And then secondly, you have to have a process where you can be a part of it. You have to be able to participate in this organized process. So that's not entirely in your control, because many people do planning and they end up with a law firm or a planning team that doesn't really provide this process. So I think this is not 100% within your control, but you can try to make sure that this is within your control by being intentional and reaching out and saying, yes, I want to be a part of something like this that's intentional and a process. So just to cover this very quickly, and then we're going to move on to broader concepts again. Traditional estate planning has no process. Documents are drafted, documents are signed, documents are stored. They are never looked at again for 19 years at a time in most cases. That is a recipe for not being intentional, not having education of fiduciaries, not really having a plan that's guaranteed to work the way that you want in the most probable way. So we don't want that traditional process. We want a process-driven, educational-driven estate plan. And that's going to be done through this intentionality concept. So again, just for your own reference, a traditional estate plan is one-dimensional. Documents are the planning with no real forethought or afterthought and no education of fiduciaries. Now, it doesn't matter how long or short the process is, but as long as we have one. So here I'm illustrating a three-step process, one of design and implementation. And this one we spend plenty of time if we have our preference. We're going to spend plenty of time doing that. Then we're going to maintain and update through education. And then at our final administration, when our plan matures and we are no longer living, we have a plan that works the way that we want and we understand how it works. So again, hey Jeff, do we have a question?
Can we pause for a couple of questions before you dive into that? Okay, thank you. First question is, shouldn't an estate plan include how distribution is made or who does it after the client is deceased?
Yes, thank you for that. If I understand that question, yes. So there are four major elements of an estate plan, generally speaking, of a traditional estate plan. And that is, who gets my tangible property, my furniture, belongings, jewelry, and so forth? Who gets any specific gifts, or what we might call off-the-top gifts, or special provisions? The balance of the estate, which we call the residuary estate, and then the remote contingent provision. What happens if none of my beneficiaries are living? So in that process, at our death, if I understand your question, yes, there needs to be a fiduciary there, a personal representative under a will, or a successor trustee under a revocable trust that is going to be charged with administering your estate after your passing. I hope that hit the center of your question.
Right, thank you. And we do have a full webinar about estate and trust administration that I can certainly send out the link to. We just offered last Friday. And next question is, how do you recommend to handle a small piece of real estate in another state, such as California, in an estate plan?
Well, thank you. That's a great question. So that's going to depend on, what kind of real estate that is. I know it's a small piece, whether it's a lot, whether it is a commercial piece, whether it is subject to potential liability with people coming on the property, whether it's a second home, but doesn't sound like it. But in an estate plan where you have assets in another state, it's going to depend. If we care about avoiding probate in that state, then we're going to use a revocable trust that may own, very likely may own, that property in that other state. So there's no probate in that state. There's no probate in Maryland, let's say, if that is your primary residence state. But if we don't care too much about that, then your will would control your property in Maryland and in that state.
Okay, thank you, Steve.
Thank you very much. So just being intentionally redundant now and circling back, we are talking about avoiding less than perfect estate planning by beginning with the end in mind. What is our goal? Beginning and end. Working with a planning team or an estate planning firm, so to speak, that offers a partnership relationship, education, leading edge legal technical solutions. Not that all clients are going to use these leading edge techniques, but to be educated about them, to make sure that assets are aligned properly, and that offering a maintenance and updating program, and making sure that we're thinking about the long-term succession, which will support your survivors. That is really the key to avoiding long-term, less than perfect planning. So the process-driven estate plan, which we might call caring for clients, and the person I met with for breakfast this morning, which I'll continue to mention because it was just so inspirational to see someone that passionate about caring for clients. This is what we're looking for. We're looking for people who are passionate to be part of the team, who support the client in your process of continuing to maintain your plan for peace of mind. Emphasis is on education, maintenance and updating, and again, it incorporates the entire estate plan and not just a single transaction. Now, we might say that estate planning, when it all boils down, is about this simple definition, but I'm going to ask you in just a minute to make your own definition or your own summary of what you think estate planning means to you. So estate planning, we might say, one definition, it's about giving away or disposing of your property the way you want to the persons or organizations of your choice at the lowest possible what? Cost. So we might say estate planning is about disposing of your property the way you want to the persons or organizations of your choice at the lowest possible cost. Let's take 60 seconds to define the best way you can, and you can go from stream of consciousness here. What does estate planning mean to you? What are things that are important to you? What are things that you would address, whether they are tangible things or intangible things, such as your legacy, your ideals, your goals and values that you wish to pass on? There are ways to do that. Or specific things that you want to accomplish for your loved ones or the organizations that you love. We'll take about 35 more seconds on this. There are no wrong answers. Some of you may wish to share. Some of you may just want to keep this private. We'll go for about another 15 seconds. I used to watch a motivational speaker who said, beginning is half done. So if you've participated in any of these exercises this morning, there's my timer. If you've participated in any of these exercises, you have moved a long way towards updating your estate plan. And not only that, updating it with intentionality. For those of you who have estate plans, you may recognize this. A will-based plan is driven by the will, that's the driving force. And you can see on the left and right, we have ancillary documents, we call them incapacity planning documents. Many of you will say, Steve, that advanced medical directive is the most important thing to me, and I would not disagree with you on that. Very important. Many of you will say, Steve, that power of attorney is important, but I'm not quite sure why, but it is, and you are exactly right. A financial power of attorney is arguably the most important of all the estate planning documents from an estate planner's point of view. Why? Because we can build in flexibility for the future. So if you guessed that as the most important of all documents, even though all of them are important, we are planning for not just death with the will, we're planning for flexibility, planning for life with that power of attorney and advanced medical directive. Those of you who have a revocable trust and you want to either change, those of you who think about a revocable trust or have a revocable trust, you're either thinking about changing to have one, or you're going to update the current revocable trust that you have. So every once in a while, it's a good idea to restate your revocable trust. There are changes in the laws, changes in techniques, changes in what I would call backup provisions that can be added. And that doesn't necessarily have to complicate your estate plan, but it certainly does lay the groundwork, lay the foundation for having a broader, more flexible plan. So here, the revocable trust is the driving force. We still have advanced directives, we still have powers of attorney, because not all assets go into a revocable trust. IRAs do not go into a revocable trust during life, and most of the time, life insurance does not either. So 2 steps to a revocable trust: creating the revocable trust, or in this case, during this webinar, our subject matter is updating that revocable trust. And then we have to make sure, as part of the updating process, that assets are properly aligned. The revocable trust should, most of the time, own non-retirement assets. All of your non-retirement assets should be retitled in the name of the revocable trust. IRAs and 401ks and other beneficiary-driven assets such as life insurance will probably stay outside the trust and should be beneficiary designated accordingly, either to individuals or to trusts for individuals. All right, let's take another 60 seconds now before I get into non-probate transfers. And I've already started my timer. Let's think about your current estate plan. What do you remember about it? And remember, some of you don't remember what you have in your estate plan. And part of the updating process is just to have someone review your documents and reiterate what you already have in place, just to remind you. But as you think about what you have, intuitively, what are the updates you think you need? What are the things that have changed in your life that you know you need to change? So let's take about another 30 seconds on this. I'm trying to keep everybody moving this morning so we finish on time and you can get on with your day. What are the things that need to be updated in your plan other than what maybe has changed in the law? What are the things that have happened in your life? We'll go about another 10 seconds. All right, so thank you for participating. I'm going to move now into the non-probate transfer. So we have wills, we have trust. These are the very basics, the wills versus revocable trust argument. Which one is better for you? That is a counseling issue. That is a goal-driven issue. Both of them are fine. You may choose one or the other as your preference, or you may have one of the other right now that needs to be updated. We can leave assets by non-probate transfers. These are some of those transfers. We have to be very careful with these because this is a one-way street. Assets go from point A to point B with no stop in between. And life can change, circumstances can change. There are no contingency provisions, generally speaking. So that's why most people use wills versus trusts rather than these non-probate transfers as the sole single device. And so here we can use these as tools, but from an estate planner's point of view, we're going to use wills and trusts generally to build in flexibility and have contingency and backup provisions for whatever life may throw at us. That doesn't mean these provisions are bad, or these types of techniques are bad. They have their place in the world of special needs planning, estate planning, elder law planning, but we have to understand why we're using them, and we have to understand the risks of using them. For example, someone could pass away who is married, and if all the assets are passing by transferable on death, what happens is many times that was an unintentional thing because the will or trust created certain devices that were important to the person who died. But the assets were titled in such a way that they went directly from point A to point B, and those assets were not controlled by the provisions of the documents. And if we do that, we need to understand why we're doing that, and we need to understand the risks of doing it, but we don't want to do it unintentionally. So I hope I've made my point there. Here is a good example of that. We've got a great will or trust, but look at the way the assets are owned. So we have to understand how assets are owned, and we have to understand how assets flow, and we have to make sure that this flow of assets, this funding of assets, this alignment of assets is in accordance with our goals and what we're trying to accomplish with our estate planning. So again, we begin with the goal in mind, and everything drives in accordance with that goal, just like in financial planning or tax planning. Jeff, I'm going to stop just to see if there are any questions before I go into incapacity and then on to other things about partnership.
Thanks, Steve. Reading my mind. One question, a good question. Does the POA die when the person dies? Do you need a will with a trust?
Thank you very much. So those are two questions, I think, and they're excellent ones. Thank you. The first question is yes, the financial power of attorney dies when the person dies, because the person is the principal. Okay, that person gives the agent power, and that is a lifetime document. And when the principal dies, the power the principal gave to the agent dies with the principal. So that's a great question. Now, the person who is either the personal representative or the trustee of a trust takes over now at death. The second question has to do with whether you have to have a will with the trust, and the answer is yes. Ideally, you would have a revocable living trust, and as you may have seen in that one slide, there is a will in the background, and that is a backup will. So that is in our industry called a pour over, P-O-U-R, pour over will, but it's a valid will, and all it does is stand in reserve to the trust. Excellent questions, thank you. So now I've set the stage for what happens during life and death, but let's get into this just a little bit more of understanding this whole concept of powers of attorney. So we have design, we have power of attorney design, we have advanced medical directive design. Now, do you have to get into all of the nitty-gritty design pieces of it? And the answer is no. But if you don't, then you're probably not fully informed about the extent of what you can do on the medical side to customize your incapacity planning, or you're not going to be taking the time to understand incapacity planning and the choices that you can make for the future in your power of attorney documents in terms of how much flexibility or how little flexibility do you want to give your agents. So in a perfect world, you would have agents that you trust so much that you can give them tremendous flexibility. And that is usually the case, but not always. So these are counseling issues. And remember, properly designed powers of attorney with agents and also with those agents getting along and a continuous updating of your documents over lifetime, you're avoiding guardianship of your property and guardianship of your person. This slide right here simply illustrates the extent to which that you can customize your advanced medical directive. This is the most important thing for some clients. So just know we here at Elville and Associates take this seriously to update and to customize advanced medical directives. The medical order for life-sustaining treatment, many advisors are being proactive about this. You should be proactive to learn about this medical order because Maryland requires it. We don't have time to get into the nuances of it today, but this is part of updating. If you haven't updated your documents since 2014, or maybe a couple of years after 2014, when MOLST, the medical order for life-sustaining treatment, came into the, I guess, the environment that we're living in today, and Maryland requires it, this is something you need to understand, and it's something that your children, grandchildren, nieces and nephews, people who are acting as your agents should understand. The Secure Act. Every estate plan, generally, there are exceptions, but nearly every estate plan needs to be reviewed simply because of the Secure Act. And now we are in the Secure Act 2.0, meaning since 2020, when this came into effect, we have a situation now where retirement plans have been enhanced across the United States, but the treatment of retirement plan assets at death has been drastically changed. So we no longer have the stretch out of IRAs except for a handful of exceptions. So if you have healthy children, healthy nieces and nephews, grandchildren that you're leaving IRAs to, those IRAs will no longer be able to be stretched out because those beneficiaries only have 10 years. When the beneficiary is at least 21 years old, they have 10 years only to take out all of those assets and pay taxes on a traditional IRA. So we have some exceptions. You don't have to write them all down, but if you want to, spouses are exempt. Beneficiaries that are less than 10 years younger than the plan participant are exempt. Chronically ill people are exempt and their special needs trusts. Disabled people, or what we might say people with special needs, are exempt and their special needs trusts. And of course, these chronic illnesses and special needs are defined by the law. And then minor children, defined as minors who are less than 21 years of age for the Secure Act. But all plans need to be reviewed, and there are some potential solutions about how to deal with this tremendous acceleration of income tax on retirement plan assets. So there are some things to discuss there. That's part of the reasons for updating. Now, as we understand that there are risks in life here, over the weekend we saw dramatic developments around the world. We are living in a risk-filled world, but there are risks just in estate planning that we want to be aware of. So when we engage in estate planning with an attorney, you could be engaging through no fault of your own with an attorney who lacks experience or focus in estate planning itself. So you could be dealing with a general practitioner and their product could be perfectly fine, or it could lack scope. So we want to make sure that we're aware of the kind of estate planning or non-estate planning attorney we're dealing with when we're getting some estate planning in place or updating it. We want to avoid a transactional process. We talked about that before. We want to have an educational driven process. There's no alignment of assets. This is a big risk. As you saw on the prior slides, you could have a great estate plan, but the alignment of assets is askew. So the estate plan doesn't work the way it's supposed to. You being uninformed, which again could be no fault of your own. Through your circle of influence or sphere of influence, you may come about doing estate planning being not as informed as you should be. But that's not you really, because you're here today learning, and that is to your credit. You have documents that are weak or inadequate. So documents come in different varieties. Now, we said we weren't focused on documents, but what I meant by that is we're not looking at documents as the only element of the planning. So obviously you need robust documents, you need flexible documents, you need documents that will provide for the power that you need over a period of time. So documents are important as to the substance of those documents. Maybe the planning lacks scope. Maybe because you did not get a proper amount of education or counseling, you were not aware of certain options that were available to you. So the plan is not as broad as it could be. So that's one of the risks. Incapacity planning is one of the big risks. Marital planning is one of the big risks. Let's go back to incapacity planning. So if we don't have the kind of flexible incapacity planning, such as that's provided with properly drafted powers of attorney, now we are at risk. I have met clients recently that have no powers of attorney at all, and they are older people with significant assets. So those kinds of people are out there, and you are not one of those people because you're here to get that situation fixed. So keeping your incapacity planning documents updated as to your agents and to the modern techniques that are available that you can either accept or reject, but at least that you're aware of what is available to you, that is a risk, especially with the loss of flexibility that would occur if your financial power of attorney were to fail because it's not accepted, because it might be old. And of course, the new Maryland Power of Attorney Act says that contemporary powers of attorney must be accepted by law. So that is a risk that you can minimize by simply updating your documents. Marital planning can be risky because we have to have counseling about how do we leave assets between spouses, and do we wish to control the disposition of assets to spouses and down to our other loved ones, or whether that is not an important thing to do in your particular case. So these are the risks that we just want to evaluate and be aware of. Concerning continuing this list of risks, we have asset protection. So some people want to keep their estate plans simple, and simple is fine. There is nothing wrong with keeping our estate plan simple. However, what I do is I ask clients, what is your definition of simple? And as we get into what goals really are, we may find that we don't want just simplicity, that we do want a little bit of complexity to protect assets. So we have to understand the kind of asset protection we currently have during our lives. We have to understand asset protection from an elder law perspective, which we're getting ready to get to. And we also have to understand the kind of asset protection we can provide others when we pass away and we have the opportunity to leave trusts for others. We have to understand the tax implications of the law. Right now, we're living in a very income tax favorable environment for estate planning, and we're living in a very estate tax friendly environment on both the state level, because Maryland has its own state estate tax, and the exemption is $5 million. And on the federal level, the exemption is $12,920,000. But we have to understand that those unprecedented exemption amounts and the element of portability, which is if you're married, you can use both exemption amounts relatively easily. We have to understand that those are at risk because in 2026, those particular high exemption amounts are supposed to be reduced. We have to understand those kinds of risks and plan accordingly, depending on the size of your estate. Elder law, we have to understand the risks of not having flexibility. I'm summarizing this broad topic because the key to elder law planning is flexibility, powers of attorney, forethought about do we want to do advanced planning for elder care or do we want to do at least be in the position to do crisis planning by having this flexibility. So understanding long-term care insurance, understanding hybrid long-term care products, and our financial advisor professional colleagues who can advise you on this. Understanding life insurance policies that have long-term care riders, understanding all of these things as they relate to elder law, and understanding care assessments and level of care assessments and the kinds of lay of the land kind of education that you can receive if you are interested in elder law concepts. These are risks if we don't understand these things and get them in place. Special needs planning, we want to understand the risks that are possible for our special needs loved ones, our loved ones with disabilities, and what is the most proper planning for them. Some beneficiaries are very clearly disabled and need special needs planning. Other beneficiaries are more moderately disabled or higher functioning disabled people, and this presents a counseling issue. Healthcare decisions, we just talked about this, understanding healthcare decisions in Maryland and surrounding states and how advanced medical directives work in conjunction with the MOLST form and understanding that with our fiduciaries. Understanding and choosing fiduciaries. Now, this is one of the greatest areas right now of a concern for many clients is how to choose trustees. Jeff and I have done a webinar together, Jeff being the moderator, of how to choose trustees and understanding that. So we have that if you would like to look at that webinar, but nothing probably in today's world other than updating our documents, nothing is more important than trustee selection and understanding how our trustees are going to work in the future. The storage of documents, the access to documents after our deaths, making sure that everything is available. This is a key issue. It's a risk. It's not as if these things will not be accessed eventually after your passing. It's just how expensive will it be and what will our fiduciaries have to go through if we don't plan accordingly. And then, as I told you in the beginning, being redundant, the flexibility. You've heard me say that at least 5 or 10 times in this presentation. Building flexibility where it's appropriate. Building flexibility or no flexibility, that's really the risk. Having an estate plan that's static, having an estate plan that's not updated, having an estate plan where there's no breathing room, there's no flexibility, that is a risk. So we just want to understand all of these risks and put them in context. So the importance of partnership, which we've talked about, is the idea that knowledge is only potential power. A good example of this, if you don't mind me using my breakfast experience example this morning, we know we're talking this morning about knowledge. We're talking about changes in the law. We're talking about all the advanced techniques and leading edge things that can be done. But that knowledge is only potential power. It's only potential power until I should say, it's applied. It's applied for the benefit of someone who understands it, the benefit of a client who can use it, and it's applied in partnership, let's say, with the planning team. So I'm just going to say knowledge is only potential power until it is applied in an intelligent way, and we want you to know that and to intentionally apply this knowledge, and now we have power. Documents are important, but only one aspect of the planning. So to succeed, we want to use this legal technical knowledge to the extent that is appropriate for you. And you need to be dealing with professionals that not only understand this concept of power and how to take this knowledge and turn it into power, but you understand as part of that is that your professional team is willing to do that. So believe it or not, willingness on the part of yourself and on the part of your professional team is really the key. You're willing to enter into a partnership for updating and maintenance of your plan. Your team is willing to enter into that partnership, but not just willing to enter into it, they are willing to help. They are willing to be proactive. They are willing to take that knowledge. And believe it or not, there are professionals and there are people, as we all know, who are very talented and they have a lot of knowledge, but they're not willing to share that knowledge, or they're not willing to participate in that process. So that's what we need, is this knowledge, the idea that it can be applied for our benefit, and also that we have a team of professionals that is willing to enter into that partnership relationship to provide the education and care, provide the longevity and so forth, and to give you and others in your family, the fiduciaries, confidence that you can attain your goal, and that after your passing, that there will be support for your loved ones. So this is what we're really trying to convey here today in this workshop. Jeff, I'm going to stop just a second. Do we have any questions? And if not, I'll keep moving on.
Thanks, Steve. We do have a couple of questions. Actually, a few here. Let's take a look here. Does Maryland also allow a person to designate a person under a pre-need guardianship with estate planning?
If I understand that question directly, the answer is yes. Correctly, I should say. If I understand it, yes, you can designate a guardian. So if you have a young person in your family, like a minor, and you're a parent, you can obviously designate guardians, and that is a really important thing to do. And that's one of the main reasons that younger couples come in. They're not worried about the future for each other, for example, so much, but they're worried about taking care of that young child who's potentially going to need a guardian if they're less than 18 years old. But if your adult disabled child is over 18, obviously, and they are either under guardianship or they may need a guardianship in the future, a good planning technique is to name a potential guardian in your will, that just in case that person needs a guardian, that they will have one named. You will nominate guardians in your will. So hopefully I've understood your question, and that's a great one. Thank you.
Thanks. Next is, can you give us an example of no or misalignment of assets?
Yes, thank you very much for that. So there's so many there. Let me think of a good one. I'll give you a good one here just because it comes to mind. So let's think about someone who is married, and I'll just use my hands if that's okay. Here are two wills. And this person here says, well, if I die first, I'm going to leave my assets to my surviving spouse for his or her benefit, but I'm going to leave that in a trust. So I'm leaving my assets to a trust, and this is something we might call a marital trust. So there are such things as marital and non-marital trusts. But a traditional technique would be, I'm going to leave assets in a marital trust. Well, now the will says there will be a marital trust. So there it is, says so right there. And if this spouse died first, which they didn't, they survived, but this spouse's will also says there will be a marital trust if I die first. So there's no question, the marital trust is in there. And it's supposed to be established upon the death of one spouse, okay? There's no question. So this spouse dies, but now instead of the marital trust being funded, that marital trust ends up having nothing in it. And the reason for that, and this is very difficult to explain over a webinar, but this couple did not align their assets. Their assets were joint. Upon the death of the first spouse, all the joint assets went to the survivor. All of the beneficiary designated assets went to the survivor. All of the assets that could have gone into the marital trust did not go into the marital trust. The IRAs that could have gone into the marital trust, if that was what was planned, which is one option, they went instead to the surviving spouse. So my point is, that would be a failure of an estate plan because the assets were not aligned properly. So we have to structure a will or trust, then we have to look at the goal of the planning, and then we have to get assets aligned accordingly.
Okay, very good. Another one or two, if that's okay.
Yes.
The pros and cons of having 2 or 3 executors or powers of attorney.
Great question. So I think with regard to having multiple executors, the same concept would be true with multiple lifetime powers of attorney, but maybe it's a bit more controlled if we have 2 or 3 executors, we have co-executors. You know, there's a process that has to be followed, and if all of these people reasonably get along and all of them agree, you know, we're really not going to have a big problem because the Register of Wills probate process kind of drives its own step-by-step process. And if they follow that process, it's probably going to be fine. Now, there's always the possibility of a disagreement between fiduciaries, and I will use the power of attorney example to be, I guess, more realistic, although it can happen in probate, obviously. Now, if we name 3 agents under a financial power of attorney, we really have the possibility of conflict, even if during life it doesn't appear that these 3 children or whoever they are would ever disagree. It only takes one person to disagree, and so we have to decide, can any of these agents act unilaterally? Do these agents have to act in unison? Do they have to act together? You know, this is a tall order considering how many years in the future things could change. So everything is based on particular circumstances for your family. So you're going to know these fiduciaries better than I, but we want to think carefully through that, because what we have in a power of attorney situation is, if these agents don't get along and if they disagree and it can't be resolved through mediation or cooler heads prevailing, it could result in a guardianship. And remember, the whole purpose of having these advanced directives and powers of attorney is to avoid guardianship. So it's not to say it wouldn't work, but we have to think about that very carefully and how to structure it versus having successive agents, or maybe not having 3 total agents that have to act together. So it's a case by case situation.
Okay, and one more if that's okay.
Yes.
Okay, what happens to assets if a non-spouse has 1, inherited a traditional IRA prior to the Secure Act, 2, had been presently taking the stretch IRA required minimum distributions, and 3, dies leaving the IRA assets behind? Does that remaining stretch IRA money get passed to a beneficiary and remain under pre-2019 rules, or does it now apply to the Secure Act?
Well, that's a great question. So there is the pre-Secure Act, and then there is what I will call a gap period. And that's the best way to describe it on this webinar. There's a gap period. I just had to answer one of those questions that I thought I would never have to answer, about a gap period question about whether or not the deceased person who left the inherited IRA, who died, who received the IRA before the Secure Act, but passed away with the IRA after the Secure Act and left it to a further beneficiary. There are specific rules about what happens. So we have our pre-Secure Act, we have our right at the time of the Secure Act, I'll just call that a gap period, and then we have the post-Secure period. So it's impossible to answer your question over a webinar because I don't know the facts, but it does take analysis if it's anywhere near that gap period where a transition of IRA assets would occur. And in the particular situation that I was looking at recently, we determined that that particular situation, not necessarily yours, that the successor beneficiary would only have 10 years to stretch out the funds, even though the prior person had a required minimum distribution based on lifetime tables, the single life tables. So it's all going to depend on when the circumstances, and I'm sorry I couldn't answer that in more detail.
Thank you, Steve. Very helpful.
Thank you. All right, thank you for those wonderful questions that make our presentation more enjoyable and so forth. So our power in estate planning comes from eliminating randomness, having a process. Hopefully I've been redundant and you've received that from me today, being intentional. Eliminating a focus on the documents and looking at a broader picture. Commitment on the part of you, a potential client, and looking at the life process, again, as the overall process. Commitment on the part of the attorney and law firm, but also commitment on to a process that involves a planning team. Now, of course, you do not have to have a planning team. It's not required, but we strongly recommend it. And again, process before planning, process during planning, process after planning. So process having this intentionality with a reference to the external, and we want to call that external the process. And then our firm tries to address that through client care program, which we have, and we're very proud of that. But not all of our clients are members of the client care program. So whether you engage in our client care program because you like the continuous education, you like the partnership, and you like this more formal process of partnership, or whether or not it's just a concept to you and you're going to commit to frequent updates with our firm, we're going to be there to try to help you do that. So this continuous updating, this legal education, not only of yourself, but of your fiduciaries, this is power in estate planning. So our client care program, Jeff is happy to send you more information about that. This is a way for us to enter into partnership with clients and to give clients a path forward to say, in this crazy, busy world that we're living in, this is a consistent, intentional path forward for my education, my continuous updating, and we offer benefits of educational and social events and discounted attorney time and so forth. And that is what our client care program is. It is not for everyone. If you don't participate in our client care program, it is fine. And the concepts that I've laid out today are still valid. So this is for the person who wants to be very, very intentional and kind of have this as a kind of a repeating, ongoing process versus a more informal process. But this is something that we want you to know about and the benefits of our program, that you know we offer this partnership program. So I won't spend time going through all the details of the client program, but I will try to end on time here and give plenty of time for any further questions. So being intentional, updating our estate plan, understanding this critical need for updating is really just a question of setting a meeting with us. It's a path forward for you. We want to see an estate planning questionnaire from you, which takes a little bit of work. It takes that partnership. We want you to understand that you can relax. When you have your planning updated, when you have a meeting with an attorney about estate planning, this is part of an attorney-client privileged meeting. So there is an attorney-client relationship. There's nothing to fear, even if you don't become a client. There's nothing to fear because it's all privileged information and it's confidential. We would like to see your existing estate planning documents, so please bring them. We generally don't charge to review documents. I have reviewed, and our associates have reviewed thousands of documents. You may just need a reminder of what you have. It is very common for us to meet with clients and the client says, I just don't even remember what I have. Let's review it. And that's very human, very common. We want to help you form an advisory team. For those advisors and professionals that are on this webinar this morning, we want to help you with your clients form teams where your clients can be served at the highest level. And for you, a non-professional that may be on this webinar, we want to help you either recognize that you already have a team or to form one, and not only form one, have the team actually talk among themselves and in your best interest. We want to answer questions you have, so please bring your questions. We like them. We want to help you. And in our conference rooms here at our firm, we have 4 conference rooms, high-tech equipped, and we can deal with your questions and concerns and illustrate answers and also sit in a quiet space to do the final thing here, which is to give you time to think. One of the things that we want to do is be very thoughtful, very educational, give you time to think about what your goals are, give you time to review documents and make intelligent choices. But our job also is to help you move forward, because see, if we educate, we also have to move to the conclusion. We have to not just get stuck in the education and stuck in the partnership. We want to get things updated and act now. Now is the time for us to act, because we want to educate, we want to participate, but we also want to act. So that is what we're trying to do for a continuous process where we can be successful ultimately. So, Jeff, it's a beautiful day. I think I've ended about 5 minutes ahead of time. So we were very enthusiastic this morning. Our audience was participatory. We appreciate it. I'm looking outside. It's still gorgeous. I'm going to turn it back to you, and I want to thank everyone for your time today and your commitment to learning and supporting our webinar series.
Thanks as always, Steve. This is a topic we can go over and over again and would never get old. Important need to update your estate planning. So now would be a great time to get any final questions that you have into Steve. You have Steve here, best attorneys in the Mid-Atlantic, right here to answer your questions. So I have him here all the time with me, but you don't. So be sure to get those questions into me right now. While we're waiting for any final questions, I'll say as far as our webinar series goes forward, we have a couple of presentations coming up on October 25th, the financial planning aspects of estate planning at 10 o'clock with Steve. And then on the 27th, that Friday, very popular presentation we do every couple months, what families need to know about planning for a loved one with special needs, also at 10 o'clock with Steve. And then we have our big annual client and community education event on November 4th at 8:30 at the 10 Oaks Ballroom. Haven't heard about it, you should have by now. We just sent out our final RSVP call this morning. It's going to be a great morning. Our theme is asset protection, protecting your legacy and the ones you love. We've got a big crowd coming, lots of great education, lots of prizes, lots of live music, great food, and a lot more, and really looking forward to the day. We've been planning it for about 8 months at this point, and I'm very blessed to have had a great committee of team members here working to get a lot of things done behind the scenes. Hope you can join us for a really enjoyable morning that Saturday. So let me know if you can come by next Wednesday. That is the last day to RSVP. No exceptions. So let's see if we have any other questions here. One more. It says, how does this change if you move to another state? I would assume meaning the process of estate planning would change if you move to another state.
Thank you for that question. So if you create a will plan, your will, if it's validly executed in Maryland, for example, is valid in any state, okay? Now, with that said, there are exceptions. So Virginia and some other states have extra attestation requirements. So we have to make sure that your will is fully acceptable in all states. And that means that maybe we would go beyond the simple attestation requirements of Maryland. But basically, your will is valid in any state. If you have a revocable living trust, that's going to be valid in any state. But once you move to a new state, it's going to be advisable to change the location of that trust to the new state. So that is a process that would be advisable. As far as powers of attorney and advance directives, those are going to be valid in any state according to Maryland law. However, if you were moving to a new state, you would want to get the power of attorney and healthcare directive documents of that particular state, in my opinion, because you're going to stay permanently in that state and you're going to want to have the documents that relate to that state's laws, and that's going to be in your best interest. And that's usually not a big deal to get those documents updated in that way when you move to a new state. Thank you.
Okay. Next question, if you're looking to update your plan, do you seek a lawyer or a CFP?
That's a great question. For example, the CFP I was meeting with this morning is a great source of let's say, being the catalyst for people to do estate planning, because our CFPs and other financial advisors are really out there providing the highest levels of service to people and an increasing demand by people for high levels of service. So they're going to be the catalyst many times to say, you need to get your planning updated, you need to get your asset alignment updated, and so forth. Many people ask this question. I guess the best way to look at it is that your CFP and your estate planning attorney should be working collaboratively. And I guess one way to look at it is, it's probably better to do your planning first, or at least collaboratively as part of the financial planning process, because once the plan is in place, once the structure of the plan is in place, we're going to know how to align the assets accordingly. So maybe that's one reason to do the planning first, but that doesn't mean you shouldn't engage with your financial or certified financial planner to do your overall financial plan. That doesn't mean that you should do your estate planning first or do that first. I'm just saying that once you do your estate planning, we will be collaborating, if we didn't already, with your certified financial planner to make sure assets are flowing accordingly. So I don't think there is a black and white answer to which one should be first, but I think it should be collaborative and doesn't necessarily mean that one has to be done before the other. I think that's something I've seen many, many times, and that's a very valid question.
Steve, would you say that, like the gentleman said this morning, that a lot of times they encourage estate planning and updating and our resources, but they don't draft estate planning documents. So that's where
Right. So our financial advisor colleagues don't draft documents, and they want clients to be proactive in getting their documents in place. The funding and alignment of estate plans does not affect the overall financial plan that you are and your certified financial planner are putting in place. So I think it's kind of a one and the same kind of thing. There's no reason why you can't do your financial planning and your estate planning at the same time, because it should be done, in my opinion, collaboratively anyway.
And it looks like our last question for now is related to our client care program, which I might be able to answer, or you, Steve. Is there an additional cost for Everplans, DocuBank, and Media, which are three of our benefits of the client care program? Steve, if you'd like me to answer that, I'm happy to. So there is no additional cost for those three benefits, which are part of our client care program. Those are included in the annual cost of the client care program. Now, if you were to go out and purchase those services individually as a non-client care program member, there are costs for those services individually. But if you were a client care program member, along with the other benefits that are on your slides today and that Steve scrolled through, they come with your client care program membership on a yearly basis. So good question. So it looks like those are all of our questions for now. Oh, wait, one more, I'm sorry. How do I ensure that my will is followed? For instance, if I follow one and survivors think, if I file one and survivors think they won't like it, so they say I don't have a will. Good question.
That is a great question. Now, that's a complex question. I will try to simplify it. So if you register your will is on file with the county. Now, people feel differently about this depending on your point of view, but my position is that obviously your attorney can hold the will if they're an attorney that stores documents like we still do, or the will can be stored at the Register of Wills. Now, if you don't care one way or the other, I would recommend that you do have your will registered with the Register of Wills, because it's on file and your personal representative simply has to start the probate process if you have a will, and it's going to be kind of automatic because it's there. Now, this is all a question of fiduciary duty. So if you have a personal representative and that personal representative does not pursue opening the estate and no one else pursues opening the estate, then obviously you're going to have a process that's going to be stalled from the very beginning. But I would say it's rare, very rare, where your personal representative would not move forward to either open your estate, or at least one of the interested persons in your life, people that would inherit under that will, or even people who were disinherited or would not inherit under the will, but they're still interested persons. And this is where it gets a little bit complex. It's kind of hard to conceive that one of them wouldn't come forward, especially if you have your will on file at the Register of Wills. It's registered in safekeeping, we call it. It's kind of hard to conceive that that wouldn't happen. Now, that personal representative or trustee, if you have a trust, that personal representative has a fiduciary duty to carry out the administration of your estate. Now, if they don't, that's a breach of fiduciary duty and they can be removed. Another thing that we see is we see someone that has a will or trust and they've put provisions in that will or trust that certain things are supposed to happen for spouses, such as a trust for the benefit of a spouse. And sometimes we see our financial advisor colleagues sometimes retitling assets, or the client, the surviving spouse, retitling assets in their own name, when in fact those were supposed to go into a continuing trust for a surviving spouse. So all of this to say that, but you know, in the world of, I guess, human nature and inertia, it's kind of inconceivable to me that maybe the argument would be made that your estate would not be opened. So I think that probably one way or the other, you can have the confidence that your estate would be opened, especially if you are selecting your fiduciary carefully and you are registering your will with the Register of Wills. But it's a separate issue to make sure that the fiduciary is carrying out the terms and provisions of your will, which under the auspices of the court will probably be the case. I mean, it's probably not going to be the case that it would be otherwise, because that's the whole purpose of the court, which is to oversee the administration. In the private administration of a revocable trust, we are putting our faith and confidence in the fiduciary to carry out the process and to make sure that our terms and provisions are carried forth, just like we said. So this is a lot to do with the system, the probate process, registering the will, and in the case of a private document like a revocable trust, we literally are relying on our trustee to carry out our fiduciary duty, or the fiduciary duty, and our plans and desires.
Steve, thanks for I'm sure it does. Thanks for the great thought and all the questions and the great presentation today.
Thank you.
And to our attendees, thanks for the great participation and your questions. I'll be sending out my follow-up message with all the information from today, including the slides, the video link, as well as the links to the webinars we've offered in the past that Steve alluded to. If we can help in any way, now or in the future, reach out to Steve or me, and as always, we'll be glad to be a resource to you. So thank you for being part of our webinar series here today on this beautiful day. I hope you make it a great rest of the day, and we'll see you again soon on the Elville webinar series. Thanks again.